We rolling?
Yep.
Okay.
You're good.
And
Welcome to the radio broadcast of Cover Your Assets. I'm attorney David Meyer, managing partner of the law firm of Meyer Wilson. This radio show shines light on investment fraud and its impact on Main Street investors. We're the voice of the individual investor. Main Street versus Wall Street is what I like to say. Today we're going to talk about a vote in Congress this week that will impact every single person listening to this radio show. If you have a checking account, savings account, this will impact your pocketbook. It was a law that was just passed, or the Senate just passed on Tuesday night while many of us were sleeping, and it's what I refer to as the Big Banks Lawsuit Immunity Act. This week, Wall Street won big in Congress and consumers lost big time. You know, it's right around Halloween, and this is pretty spooky news. This will definitely scare you. I look forward to talking about it in this show. And as a result of the Senate bill that was passed late on Tuesday night, lawmakers made it just about impossible for us to sue banks and other financial companies for deceptive business practices or fraud. We're going to get into this quite a bit, but if you cannot listen to this entire show now, we put the radio show up on our law firm's website on Monday mornings, and the law firm's website is www.investorclaims.com. That's the website for my law firm, and if you haven't listened to this show before, I want to introduce myself again. My name is David Meyer. Again, I'm the managing partner of the law firm of Meyer Wilson. Our firm is devoted solely to investor claims and class actions, and the investment fraud lawyers at Meyer Wilson chase down the bad financial advisors and brokers across the country who lie, cheat, and steal from their clients. We have a saying at Meyer Wilson, there's only one thing to do with a crooked stockbroker, and that's straighten them out. Our consumer class action lawyers pursue large-scale consumer fraud cases in state and federal courts across the country. Over the past 18 years, we've recovered over $350 million of cash for our clients. And again, our website, you can learn more about our website at www.investorclaims.com. I want to get into the meat of our topic today. Congress passed, again, what I refer to as the Big Banks Immunity Lawsuit Act. So let me give you some background. For many years, virtually all banks, credit card companies, student loan lenders, auto lenders, and other financial services companies have included it as boilerplate small print language in their customer agreements, provisions that force consumers to waive their right to go to court, waive their right to a jury, and force them that if they have any complaints against the company, they must pursue those in private, secret, binding arbitration. These agreements that are stuck in small print in the customer agreements also ban the customer from joining with other customers who might have similar problems and pursuing a group or a class action lawsuit. They're called pre-dispute arbitration agreements and class action waivers, and they've really become ubiquitous. They're basically in every form agreement with most financial services companies. And they're called forced pre-dispute arbitration agreements because you are agreeing, so to speak, although most people don't even realize that these provisions are stuck in the agreements, but they're called pre-dispute arbitration agreements because you agree to give up your right to a jury and to a court prior to the time there's actual dispute. These are not post-dispute agreements. They're called pre-dispute arbitration agreements. And they're in such small print, and they're buried. Most of them online, you click that you agree without even reading them. But they've become extremely popular for banks and other financial institutions because it basically gives them a free pass to take advantage and operate in these fraudulent schemes at times. And there's no real legal remedy for consumers because most people, if they see a $5 charge on their bank statement or a $2 charge or a 50-cent charge on their bank statement, they may not realize it. And then if another person realizes it and wants to pursue it in court by banding together, these pre-dispute arbitration agreements prevent them from doing that. So that's been going on for a long time. And as a result of the mortgage crisis that led to the Great Recession, Congress formed an entity called the Consumer Financial Protection Bureau. And they formed it, this was Congress formed as a result of the financial crisis. They formed it as a watchdog group. It was part of the Dodd-Frank financial regulatory reform that passed in 2010, I believe. And the Bureau was designed to be independent. And that new law, the Dodd-Frank law, called upon the Consumer Financial Protection Board, also known as the CFPB, to study the use of mandatory arbitration clauses. So now we fast forward from 2010 to when the CFPB was formed to, let's go to May of 2016. The CFPB issued a proposed rule prohibiting pre-dispute arbitration agreements in consumer finance services agreements. So this proposed rule would prohibit mandatory pre-dispute arbitration agreements in consumer agreements for items such as checking accounts, savings accounts, credit cards, student loans, payday loans, automobile leases, and other types of consumer loans. Now, there are some exceptions in this proposed rule. For example, there was an exception for brokers that were governed by the SEC and FINRA, and we'll talk about that a little bit later. But this arbitration rule was the result of more than 5 years of careful research and open deliberation by the CFPB. And there's a study they issued, and you can find it online. The CFPB found that blocking these group lawsuits or class action lawsuits made it nearly impossible for most consumers to get justice and relief for their wrongdoing. It basically prevented the consumers from holding these big financial institutions accountable for their wrongdoing. And the reason why, I mean, it makes sense. For example, and I mentioned this earlier, nobody is going to pursue a claim over $10. But if you band together, that can add a lot of money. I've always said it's a lot easier to defraud 1 million people out of $50 than it is to cheat one person out of $50 million. But either way, that's a $50 million fraud. And with these pre-dispute arbitration agreements and class action waivers, these types of $50 million frauds, these $50 frauds on 1 million people, nothing happens because nobody goes to an arbitration, this private secret arbitration that's governed by an arbitration institute that most people aren't even familiar with. Nobody does that. And since they can't go to court and band together, then that type of fraud is just lets go. So let me give you another example, because this is something we hear all the time at our law firm at Meyer Wilson, and it involves what's known as the Telephone Consumer Protection Act. And in an effort to address a growing number of telephone marketing calls, harassing calls by telemarketers, Congress in 1991 passed what's known as the Telephone Consumer Protection Act, the TCPA. And the TCPA restricts telephone solicitations or telemarketing, and it restricts the use of telemarketing through the use of automated telephone equipment, so robocalls. This law passed in 1991 puts significant restrictions on companies using telemarketing efforts through the use of robocalls. And we all get these on our cell phones. It was specifically designed primarily for cell phones. We all get these calls, even today, on our cell phones for robocalls. I mean, I get several a week. And the TCPA was designed to prevent that. So let me give you a specific example. Let's say you open up a bank account at a major national bank. When you open up that checking account, and you want to deposit a couple $100 in there, you signed a customer agreement. And that customer agreement generally will prohibit you, as I mentioned at the outset of the show, will prevent you from ever pursuing or joining a group or class action lawsuit for any type of claim you may have. So let's say you start getting calls, robocalls, and we know what they are. You pick up your phone and there's a delay of couple seconds because the computer that's dialing millions and millions of phone calls a day realizes with a computer that you've picked up your phone, there's a couple seconds, there might be a beep, and then someone comes on the phone. Everyone knows that's a robocall. And if you are getting that call on your cell phone, and if you don't consent to that call, then that call may be a violation of the TCPA. So let's go back to the situation where you have the account with the bank, and that bank also has a credit card division. So the credit card division gets your name and your cell phone number because you have an account at the bank, and they call you using a robodial to solicit you to market a new service, another credit card, for example. And you say, look, I don't want this credit card, no thank you. And by the way, I'm revoking consent. I do not want you to call me with these computers and robots on my cell phones. It's annoying, and I don't want it, so please stop. Well, let's say they continue to call you with a robocalling device on your cell phone, and that's a violation of the TCPA. And for every violation of the TCPA under certain circumstances, that company is responsible for a $500 penalty. Now, but because you signed the customer agreement to open up the checking account, that agreement right now will prevent you from pursuing any class action. So even though that company is making millions of calls to millions of people, sometimes a day, and many of those folks are getting calls on their cell phones where they haven't consented to those calls or revoked consent, then that company is potentially violating that federal statute millions and millions of times, and there's absolutely no accountability in court. Because who is going to find a lawyer to file an arbitration in the secret arbitration process to file a claim for $500? Nobody's going to do that. And we get calls weekly at our firm saying, I am getting these robocalls from such and such bank or such and such financial institution. I don't want them to keep calling. I beg them to stop. They will not stop. And I tell them there's really nothing you can do about it because you are prohibited with the pre-dispute arbitration clause and class action waiver. You are prohibited from pursuing or joining a class action suit. So that because of that, these companies have no incentive to stop doing it. It doesn't matter that there's a statute prohibiting it. It doesn't matter that we are all annoyed beyond reasonableness for these calls because there's nothing we can do about it in the legal system. So that's a real life example, and I know all of us are getting these annoying calls. A lot of them are scams, but many of them are from reputable companies that are trying to solicit a service, and there are rules to prevent those kind of calls from going to your cell phones if you don't consent, but because of these pre-dispute arbitration provision and class action waivers, there's very little we can do about it oftentimes. So, the CFPB rule, which would have gone into effect in 2018 if Congress would not have overturned it this week, would prevent financial institutions like banks and credit card companies from striking lawsuits filed by wrong consumers. So, therefore, these companies would have been prevented from putting in these boilerplate forced arbitration and class action waivers in their agreements from their customers. It would not have banned a lot of the opposition from Wall Street and the financial services companies. Their lobbyists were arguing that this would now ban arbitration. But this rule would not have banned arbitration. But unlike the current system, the consumers would then, under this new rule, they'd have the option to voluntarily agree to the form after the dispute arose. No one thinks about any of this stuff. I mean, sometimes lawyers, of course we do, because this is what we do for a living. But most folks who sign up for a credit card or an auto loan, they never think about what form they may choose to use to pursue any complaints, because no one thinks, or no one hopes, of course, that they're ever going to have a problem at the outset. It's always a post-dispute issue. So this rule, had it been allowed to go into effect, would have still permitted consumers, if it was such a great process, then consumers would choose to use it after the dispute rose. And so this rule was proposed by the CFPB in May of 2016. It was supposed to go into effect in 2018. And then Congress, first the House and then the Senate, proposed a bill to repeal the rule so the rule would not go into effect. But every consumer group was in favor of the rule banning forced arbitration and class action waivers. The military member groups, the senior citizen groups, the civil rights group, every consumer group, I did the research, and every group that represented consumers was in favor of the rule by the CFPB. We're going to take a short break. When we come back, we're going to talk about the bill in particular and who was really behind this bill that passed under the cover of darkness this week in the Senate. We'll be right back. I'm David Meyer with Cover Your Assets.
All right, you got about 11 more minutes.
Okay, very good.
All right. Ready to roll at part 2? Okay, here we go.
Welcome back. I am David Meyer with Cover Your Assets. I'm the managing partner of the law firm of Meyer Wilson, and we're talking about a new law that was passed by the Senate under the cover of darkness. I've got a blog I wrote about this the morning after the law passed. You can find it on investorclaims.com. It's October 25th. The title of my blog is Congress Votes in the Middle of the Night to Give Big Banks Immunity from Lawsuits. This is a Senate vote. It was 51 to 50, and many of us were asleep during the vote. But this vote repeals the rule put in place by the Consumer Financial Protection Bureau. In fact, it was so close that Vice President Pence, had to come in and put in the tie vote. So it was 51 to 50. There were 2 Republican senators that voted against the bill, which means they voted to let the CFPB rule go into effect. But as I mentioned prior to the break, every consumer group was in favor of this rule banning forced arbitration and class action waivers. In fact, a poll that was done by the Republican-leading American Future Fund found that 67% of those surveyed were in favor of the rule proposed by the CFPB banning these clauses, including 64% of Republicans. So all consumer groups were in favor of the proposed rule from the CFPB banning these clauses. All the consumer groups were in favor of it. The majority of the voters, Republican and Democrats, were in favor of the rule. But despite that, the bill was voted on Tuesday night, and it was entirely, this bill that was voted on Tuesday night by the Senate to kill the rule was entirely and exclusively supported by the finance industry. It wasn't 80-20, 90-10. It was 100% exclusively financed and supported by the finance industry. The financial industry, when this rule was proposed in 2016, Wall Street lobbyists, the lobbyists for the finance companies, really went to war. They spent millions of dollars lobbying Congress to overturn the CFPB rule. This has been an effort for a couple years now on behalf of Wall Street lobbyists to overturn this bill. Again, it was a late night vote. It was 50-50 with Pence, Vice President Pence, breaking the tie. So now this law will allow big banks to enjoy absolute immunity from customer lawsuits of any kind. It's a huge win for Wall Street lobbyists. So there's now no incentive to prevent abuses such as the Equifax data breach or Wells Fargo opening up millions of fraudulent accounts without permission. There's now no incentive for this not to happen because there's not going to be any remedy in court. I'm going to talk about the Wells Fargo and Equifax data scandal because I think a lot of people are familiar with the fact that over the last few years, Wells Fargo opened up, I believe, 3.5 million fake accounts. They actually opened up fake accounts for their customers where their customers did not authorize, did not know about. 3.5 million accounts. So what happened when that came to light? Well, consumers, their customers, were upset, wanted to pursue claims for the damages caused by having over 3 million accounts opened without their approval. What did Wells Fargo say? Sorry, you can't sue us because you signed a pre-dispute arbitration agreement and class action waiver. That was the response. And you can see in Congress, I think it was the CEO of Wells Fargo in testimony standing by this pre-dispute arbitration provision as a way to defeat a legal recourse for opening up 3.5 million fake accounts. So what's interesting in this case with Wells Fargo is they got so much heat because it was such a big deal that Congress got involved, and ultimately in this instance, I believe, Wells Fargo caved and said, okay, we're going to waive the mandatory pre-dispute arbitration waiver and class action waiver, and we're going to let this case go to court. There was a class action. I think they agreed to pay something like $150 million. But that's a perfect example. That was a huge fraud. And Wells Fargo just agreed to waive that provision. But banks are not going to do that on cases that don't get that kind of publicity. It was only because in that instance they got so much publicity that just from a PR standpoint, they couldn't withstand all the bad press. So they said, we know everyone hates these pre-dispute arbitration agreements. We know that the majority of the public can't stand them. And because we're finally shining light on them, in this one case, we're gonna let it go to court and let the legal process work. But could you imagine if it hadn't got that much press and all the other frauds and all the other deceptive practices that are out there that don't get that kind of fraud, that $150 million that was paid back to the consumers, in any other case, it's not going to happen. Those frauds will continue as so long as these pre-dispute arbitration and class action agreements are allowed to stand, because they're never going to see the light of day. No one's going to pursue these cases in court. Let's talk about the Equifax data breach. That was something like 100 million accounts that were exposed. And again, there's a class action waiver and pre-dispute arbitration agreement. So and these are just two examples of cases that lawyers like me see every day. And only a couple of them see the light of day because they're so massive. But every day there are $5 million, $10 million, $20 million, $30 million scams that impact millions of Americans, and they all get shoved under the carpet because of these pre-dispute arbitration agreements. And it's a real shame that the Wall Street lobbyists won and consumers lost big time, because it's going to continue now because there's no incentive to stop it. So what happens next? We saw in the past 2 years just these big two ones. These scams with Equifax and Wells Fargo. So now that the Senate has passed this bill, the House had passed one a while ago, the President is expected to sign the bill to completely repeal the CFPB's rule and also prevent a similar rule in the future. So they basically killed it. So now these pre-dispute arbitration agreements are going to stand in these financial service agreements. So what's going to happen next time there's a fraud? I mean, it's going to happen again. We see it all the time. But what happens the next time when there's a big enough one that catches the attention of the nation? And then we're going to look back at this vote. Are there going to be any consequences? I mean, I don't know. We'll see. But this is an example of the type of fraud that completely gets washed away and uncovered. And it's going to be really interesting in 6 months or 12 months. We see another fraud like the Wells Fargo scam or the Equifax data breach, when the customers are going to be prevented from pursuing any legal recourse because of these pre-dispute mandatory arbitration agreements. So, stay tuned on that. I want to talk briefly, because if you listen to my show, you know that a lot of the work we do is on behalf of individual investors who've suffered losses as the result of fraud or misconduct by their broker, investment advisor, or brokerage firm. And cases that we pursue on behalf of individual investors who have claims against their brokers do go through a separate type of arbitration process through the Financial Industry Regulatory Authority, FINRA. So a lot of the work we do is FINRA arbitration. So on the one hand, we spend a lot of time and energy representing folks. We represented over 1,000 individual investors all throughout the country in claims against their brokers in FINRA arbitration. And that has been the way since a Supreme Court decision in 1987. In my opinion, though, FINRA arbitration is much different than the arbitration for individual consumers that might have small claims for $5 or $10, because nobody on the consumer side, what we've been talking about for most of the show, nobody's going to do that. So it's not all the time that arbitration is super bad. It's that nobody is going to actually employ or utilize that venue, because nobody's going to hire a lawyer over $10 or $100 or $500. But if you go to your broker and entrust them with your life saving, and they steal it or they recommend an inappropriate investment and you lose your life savings, well, that obviously is a large enough amount that's worth hiring a lawyer like me, that's going to represent you on a contingency fee. We're going to advance the expenses, and we're going to pursue it through the mandatory FINRA arbitration process. That process is also binding, but the process has been improved a lot as a result of the work that lawyers like me have done to improve the process. The selection of arbitrators is a decently vetted process. The exchange of documents through discovery, that has been, the FINRA arbitration process has been worked on and improved upon and dissected over the last 20 or 30 years, and it's a decent system. There are certainly flaws, and lawyers like me are working hard to continue to improve arbitrator selection, the diversity of the arbitration pool. And there's a lot of issues that we're dealing with, but it's a lot different than a typical consumer situation that might have a small claim that's prevented from pursuing a court case because the claim may be too small. So I wanted to make sure that everyone, our listeners, understood the difference between the work we do on behalf of individual investors in FINRA arbitration as opposed to the problems in the consumer arbitration context with respect to the financial services. So I hope you enjoy the show. If you missed part of the show, again, it'll be on our website Monday morning at investorclaims.com. You'll be able to listen to the entire show along with prior shows as well. So until next time, thank you for listening. I am David Meyer with the law firm of Meyer Wilson, signing off on Cover Your Assets. Thank you.
Excellent.
All righty.
Hope that wasn't distracting. I was going to
No,
5,
it's
4,
perfect.
3.
Perfect. I appreciate it.
Everybody that I've